My name is Chip Ward. I'm an attorney with Ward & Babb. We're right down the street at 3069 Williston Road. I'm pretty close to 35 years in the trade, and the last 15 of it I've spent 60 or 70% of my time with small business. Sitting to my left is Hethba Fatnassi. Hethba is a law clerk at our office. She joined us about 3.5 years ago. She's a graduate of Wheaton College and received a degree in international relations and French, and also studied international economics. Based on her success at Wheaton, she was offered a fellowship at the University of Pittsburgh and received a degree in political science and research methodology. Highly recognized as a student, and as evidenced by a number of national awards that she received, and we are very fortunate to have her with us. She is eligible to sit for the Vermont bar within the next year or so, and my sense is she'll be very ready to handle that challenge. On my far left is Will Toll. Will and Hethba are both native Vermonters, and Will attended Yale University and did his law studies at the University of New Mexico, and fortunately for Ward & Babb, he decided that Vermont was a nice place to raise a family, and he joined us 8 years ago, 9 years ago?
Yeah, something like that.
Yeah, something like that. So we're very pleased that he came home to Vermont and he's with us.
So tonight we're going to discuss the whats and hows of your business. So we're going to talk about some of the common entities and the non-entities and what that means that are operating in Vermont. We'll talk about some of the risks you might encounter, your liability and exposure in running a business. We'll talk about some of the formalities that you need, including some of the agreements and types of paperwork that you might want for your business. We'll talk about taxes, tax filing, and some of the state laws as they apply. Some of them are defaults, so we'll talk a little bit about that. So first, the non-entities. So there are a couple types of non-entities that typically operate in Vermont. One is sole proprietors, and some of you have said you're interested in being a sole proprietor, running an LLC. So a sole proprietor in its truest meaning is a single individual doing some sort of business. This could be as simple as someone who is a handyman, goes out and does handyman services. Now they might be a little sophisticated and say, I'd like to have a trade name, and I'm going to name myself Tom's Handyman Service. I'm still a sole proprietor, just doing business as myself. The other type of common non-entity that operates in Vermont is a partnership. And the simple definition of that is 2 or more people who associate in business with the intention to make a profit. So in that scenario, a partnership could be 2 kids that have a lemonade stand. Or it could be 2 kids who are really savvy and got a trade name for their lemonade stand. But they're still just 2 individuals without any legal protections or limitation on liability operating their business. So these are pretty common in Vermont to find Joe or Tom or Jane or Judy running their business on their own. But tonight we're going to explain some of the pitfalls of operating as a non-entity.
We're not big proponents of someone operating as a sole proprietor simply because there are better options available in Vermont. And the same is true with a partnership. The 2 kids who get together to put a lemonade stand together, they are partners for every purpose. One of the real downfalls of being a sole proprietor is that you have unlimited liability, meaning if you make an error or omission out in the marketplace, you've got liability. And that liability can extend to your CD, your savings account, your stock and bond portfolio, and potentially some of the equity in your house. We do have a homestead exemption in Vermont, and we also have an exemption for retirement assets, but anything else that you might have, the homestead exemption is up to $125,000. But any other assets, in a general sense, any other assets that you have are subject to being attached if you cause some problems out there in the marketplace. So always best to avoid the sole proprietorship. The partnership is the same thing. The partners have no limited liability in a straight general Vermont partnership. And they're folks who don't see attorneys. So they're out there doing business as a partnership. They may have no agreement. But the downside of that is that if your partner is of modest means and you are a person of greater wealth than your partner, you're the deep pocket. So if there's no limited liability and you're doing business as a partner, the general public who you served can come after you, the deeper pocket, and that would put you in a bad situation if you were sued individually for your business obligations. Vermont law allows for the formation of entities, and these entities do provide limited liability, and the first that I'll talk about is an LLC. So the key element in an LLC is the limited liability that it provides. The beauty of an LLC is that you can operate as a sole proprietor for tax purposes, or you can be a partnership within an LLC, and you can elect to be a subchapter S corporation, and we're going to talk about these concepts, or you can elect to be a C corporation. So one of the reasons that you see many LLCs in our community in the last 10, actually it came about in I think 1998, but particularly in the last 10 years, you see LLCs all over the place. Well, the LLCs are beneficial because of their flexibility. They are a little simpler to put together and manage, and they are extremely flexible in their use. And you have choices, check-the-box choices as to how you wish to be taxed. And depending on one's income, revenue stream, your business plan, if it's accurate, then the accountants or we can help you choose where you should be to get started. So a regular corporation has double taxation. I use the example of IBM when I talk about this concept. IBM pays corporate tax when it has a profit. If you are an IBM shareholder and they issue a dividend, those dividends are taxable to you as income. So IBM is a C corporation. It pays tax, and when it provides dividends, you pay tax. And that's the concept of double taxation in a C corp. So the LLC is a flow-through for tax purposes in most instances, and we'll get into the taxation of the LLC in a few minutes. So the LLC itself does not pay tax on its income. In most instances, it flows through to the membership. So you have singular taxation for the most part with LLCs, with a little bit of exception that we'll talk about.
Okay.
Will? Exceptions?
Yeah, so my predominant background as an attorney, although I do a lot of business law, is as a litigator. So which is to say, I often see the instances where things have gone bad, where things have fallen apart, where someone's made a mistake, or through no fault of anybody, something terrible has happened.
Stuff happens.
Because stuff does happen. And that's really where I want to just reinforce what Chip says. You need some sort of liability shield out there, because if you are operating as a sole proprietor or in a traditional partnership and something terrible happens, your personal assets are at risk. Not just the money that you put into your company, but everything else that you own. And that's a really uncomfortable situation for you. It's uncomfortable for your lawyer. It's going to be expensive to get you out of it, even if we can get you out of it. And that's not always possible. So everyone who's doing business in America needs to be doing it under one of these umbrellas. So I really want to tell you, and I could tell you the horror stories. People who, and I thought about one of my clients when I heard about your little pottery shop there, because I had a client, one of the first jury trials I ever tried was a woman who painted silk ties. She had a little craft shop in her attic. She took it to fairs and trade shows and things like that, and she was at a fair one day in her little 10-by-10 cubicle, and somebody trying to look at one of the ties pulled a display case over on top of them. 2 years later, we're in court for a week, $1 million claim, brain damage. Sold, doesn't have an entity, everything that person had ever owned was at risk. Now, fortunately for her, we were able to get a defense verdict in that case, so there was no judgment against her. But you think to yourself, well, how could something like this happen? I'm doing something that won't get me sued. Pretty much everything you do might get you sued, because stuff happens. So I want to just reiterate that, because I'm the guy you're going to hear some of the doom and gloom stuff from, because I'm the guy that it lands on my docket when some of these things have gone wrong.
We pass it.
So, and a lot of it, and this is really the important part, is a lot of it's avoidable. I've been involved in a lot of litigation lately that it's all because somebody didn't have a piece of paper in their file that would have cost $10 for a lawyer to produce, or something like that. So we're going to talk about some of that here. But
Basic exceptions?
the basic exceptions, though, once you have that liability shield, it can still be undone. And one of the number one things, because you think, okay, great, I've got the LLC. I'm good, right? Well, you're good as long as you continue to stay within what the law requires you to do, because you can undo it. You can undo it on purpose or accidentally on purpose by entering into, like, for example, the very first thing a lot of entities ask, like a lot of landlords ask for, is, will you personally guarantee this? Okay, I'm leasing the space to your LLC, but will you sign this personal guarantee? You say yes. Guess what? Now you're back personally involved in that lease, or in that loan, or on that credit card, or on that car. So you have to be wary of the personal guarantees. There are other things. Of course, the state of Vermont, by granting you this LLC, is not going to harm itself. You forget to pay your taxes for your LLC. They will come after you personally for that.
Withholding taxes.
Yeah, with certain types of taxes, withholding taxes. And also, of course, you can't use your LLC. You know, the state of Vermont, who grants you your LLC, wants you to use it for good and not evil. Big surprise, right? And if you do use it in something they would consider to be evil, which is say you've defrauded someone, or something like that, or you put it in a situation where you're doing something shady, they can obviously, the law allows them to come around that, and you'll find some judge saying, yeah, the LLC shield is fine, but you're doing something that the law doesn't permit, so we're going to let you come through that LLC shield and make you personally liable. And then the final thing that this is a requirement, and a judge will look at in these cases, is whether you are basically acting like an LLC. Which is say, are you telling people that you're an LLC? Are you keeping your LLC money and assets and stuff separate from your own LLC? Or for all extended purposes, is the LLC hidden from everyone, and you're just kind of doing it, taking money out of your wallet for the LLC, putting it back in your wallet for the LLC, not really operating as a separate entity? Those things will also undermine the liability shield. Something that a lawyer can help you sort of as you go through this. So having the LLC itself is a very important start, but it can't end there. You have to continue to operate within the parameters of what the law says an LLC does to enjoy the protections of it.
Do all states recognize the limited liability shield?
They're just as recognized now as corporations everywhere.
That's what.
So, keeping in mind the importance of using your LLC as a shield, the first thing you want to think about is naming. So, the standard that the state of Vermont has, when you're thinking creatively about what your name might be, is that it has to be distinguishable on the record. And in practicality, what that means is it cannot be too similar to something that's already registered. It cannot be confusingly similar. And that's important for a couple reasons, but it's also important to you as a business owner because you want to make sure that your name is memorable to your customers, that you remember what your name is so you can use it, and that it makes sense. So, for instance, we have a couple examples here, and when you use an LLC name, you need to include either LLC or LTD liability company, limited liability company, or limited company in that name. That lets people know that you have limited liability and you're a limited liability company. So we have a couple examples up here of names that we think might be good. Hansel and Gretel Oven Sales and Service LLC. You're going to remember Hansel and Gretel sold you ovens. But you might not remember HG Ovens, and even less likely HG LLC can't remember what they sold. So you want to pick something that's memorable, and I'm sure branding next time around will give you a little bit more information about that. You also, one woodland cottage, if you're a property owner and you have multiple properties, you're getting really successful. You want to have a name that identifies each property so you can remember, oh yeah, that's number 1 on the street, that's number 3 on the street. You don't want to name it initials or unrelated names that will make it hard for you in the future to
Hard
use
for
that.
you and your accountant and your attorney. In other words, if you're buying
Everybody.
apartment buildings, we're a big proponent of using the address of the apartment building, 129 Main Street, comma, LLC. And the reason is because if you buy 5 of them over a period of years, now we've got Smith Investments and Smith Properties and Smith Enterprises, and before you know it, your accountant's got the schedules on your income tax return so goofed up that you wish that you had used the property address, because no one will make a mistake with that LLC if you're using the property address, comma, LLC. The same is true of personal services. If you're going to hold yourself out in the public, it is, for a personal service, it's very good to have your name involved, because people are more likely to remember your name than they are GPC Realty. I had a client, GPC Realty, and I finally convinced him to amend it to his name, and he's come back to me 3 years later and said, boy, what a difference that made. Because people just aren't going to remember initials the way they will remember your name, particularly if they hire you. They're much more likely to remember who you are than the name of your company. So the other good opportunity in choosing a name is to describe what you do. So if it's a product, it's pottery, it's arts and crafts, pick a name that describes the fact that the LLC is involved with that particular art or that particular craft, so that the public will know immediately as soon as they see that name, comma, LLC, that what you're involved in. That can be extremely beneficial as well. So choosing your name is extremely important, and we're very active with our clients in choosing a name, because we see them go up and we see them come down, and if they choose a good name and they're skilled and they work hard, they generally will succeed. We have a very small percentage of our startups that actually call us up at the end of the year and say, hey, this isn't working, I'm going to terminate this whole operation. So getting a good start, getting the right name, and marketing, which you'll learn about next month, is key to your success. Doing a good job and providing good service is also very helpful. So
I've got a couple more slides.
Okay.
So, who owns an LLC? Well,
Oh, sorry.
no,
Really,
yes,
actually,
no,
yeah.
that's good. We have a couple people who own LLCs. But what you might not know is what you're called as an LLC owner. You are members, and you own membership interest. So here we have what we call a single person or single member LLC, and it happens to be owned by Jane Smith, who's the member, and she owns 100% of her LLC, Jane's Ironworks LLC. We have a nice name. We can guess what she does. And it is, and Chip's going to talk a little bit later about the taxation, but just a very summary level, it's what's called a disregarded entity. And what that means is it can use Jane's personal Social Security number, it doesn't have to have an employer identification number, to file taxes, and that gets filed as a schedule to her personal tax return. Now, if Jane's very successful with her ironwork, she makes a lot of profits, she starts to hire employees, she takes a wage as the owner of that company, she can then elect to be taxed as an S-corp. And Chip will talk about that a little bit later. So those are just the basics of just a very simple single person LLC. And if for some reason a bank or somebody does demand that Jane has a EIN, of course you can go get one, that's not a problem, but you don't necessarily need one. So then we move to the multi-person LLC, and this is our memorable company, Hansel and Gretel Oven Sales and Repair. And we have two owners here, the two members, each owning 50%. So one thing to keep in mind is if you're a husband and wife, you're a two-member LLC, even though the legal entity that you are might be tenants by the entirety.
fill in the blanks there. The state of Vermont recognizes a marriage as a fictitious taxpayer within the confines of the state of Vermont. So it's a person under the eyes of the law, the marriage, a separate person from each individual spouse. So the state of Vermont says, look, if you're husband and wife, you can file a Schedule C on your individual income tax return as one person, and we're fine with that. But the feds, on the other hand, say 2 or more people engaged in business with the intent of creating a profit, you're a partnership. So we want a partnership return. And there are failure to file penalties, failure to file the partnership return penalties, if you file a Schedule E on your individual income tax return. So husband and wife in business are considered a partnership at the federal level. So you're going to have to fill out a partnership return, and you are partners.
What if my wife becomes a business owner and I end up working for her?
No, I don't. I'm not.
As a volunteer, day and night as a volunteer, or would you be an employee?
I would be an employee, yes.
Yeah. So, and that's fine. She can be a single person LLC owner, and you're hired as an employee on a full-time, part-time basis, whatever the thing. She's got to have payroll in place. She's got to have workers' comp in place for your protection. But there's nothing wrong with that. But the message in this section is really that if you're a multi-person LLC, you have to file. You have to make some choices about how you want to be taxed, and we'll talk about that in a minute.
So initially, as we have here, they would be taxed as a partnership because there are 2 or more people, but they can make elections, as Chip will talk about a little bit later.
The default position is you're taxed as a partnership. Partnership return, minimum tax to the state of Vermont of $250, and file a partnership return. Each partner gets a K1. Essentially, the partnership distributes gross earnings to the individuals, and you both file quarterly returns if there are 2 of you as partners, and you're an LLC taxed as a partnership. So you get your gross quarterly from your partnership, and you file by the 15th of the following month after the end of the quarter. You have to file individual income tax quarterlies, so where you pay both the state and the feds on a quarterly basis. Unless, of course, you've got an out-of-state resident as one of the partners, and then Vermont demands that the LLC partnership collects the tax and remits it to the state of Vermont directly.
This is sort of general, I'm just wondering, does all of what you're saying about LLCs also apply to L3Cs?
No.
Okay.
Okay. So we'll spend just a brief moment on that, because it's quite unusual in Vermont we don't have a lot of them to date, but they may come. There may be more of them with time. We don't see too many of them. We have done very few in our practice.
So I'm going to turn it over to Will. He's going to talk a little bit about who manages and how an LLC is managed.
So we're still on the topic of LLCs, believe it or not.
There's a lot of material.
I did want to make one extra comment on the name. Google it and go to the U.S. Patent and Trademark Office to make sure that nobody has a federal name that's similar. I don't care if your last name is Exxon, but if you name your company Exxon Lawn Care, there's going to be trouble. Okay? I've been there for clients. It's very expensive. So it's something just to avoid some trouble. See who else out there is using your name. See if they've got a better claim for it. See if they might be inclined to come after you.
Many clients get cease and desist letters from the national corporations when some local guy decides he's going to use a national company's name. So
Google and who else?
The U.S. Patent and Trademark Office, uspto.gov. They have a very good search. You can see who's out there. You might even find that it's available, and maybe you want to go through that effort of getting the federal registration done. But it's just one of those easy things to do. It'd take you 5 minutes now. It could cost you a lot of money later when Exxon or Nike or some big company comes in and tells you that you're going to change your name, because if they beat you to it, they will make you change your name. So let's talk about the management styles. So this really has to do with how big you are and how you're going to operate. This is a choice you have to make when it comes to LLCs. There are 2 ways to do this. One is the member-managed LLC. That's where every owner, which we call members, is involved in all the important decision-making. The presumption is also that they're all going to be involved in the profit sharing, and this is really the situation where you guys are, in reality, partners of some sort. And that's the choice for member-managed. The other choice is what we call a manager managed, where the membership selects basically a professional manager. And most of the time, this is good for two situations. The primary situation is where you really have one person who's in charge of this company and they have a couple of silent investors. So that person becomes the manager who's calling basically the shots, and the other people are not involved. They're basically, they own it, but they're not really involved in an equal shares the way a member-managed LLC is. So the member-managed LLC I sort of view as, that's the sort of traditional thing where you have a bunch of people who are basically all equal partners in it, versus the manager-managed where you have one person who either has the largest stake, or sometimes in the circumstance where you have people who have a sort of passive investment and they really need a professional manager to come in and handle something for various reasons. Most circumstances we see, in many cases, it's member managed. I want to other types of LLCs that don't apply to most people here. Professional LLCs, certain professions, typically lawyers, doctors, things like that. Their professional organization will tell you that you have to be a PLC or a professional, basically, version of this. If that's you, you probably already know it. And there's some additional restrictions, but it's basically the same idea with a different name for those unique circumstances. I did want to talk a little bit about the low profit or the L3Cs. I know we have some people who are interested in that, and a lot of this applies to the benefit corporation stuff that we talk about. This is, as Chip indicated, this is a relatively new idea, but it's designed to bridge the gap between a traditional for-profit LLC, which is presumptively responsible to all the members to make as much money as it can all the time, and a nonprofit organization that has nonprofit federal tax status, which is a rigmarole to go get and may not apply to your circumstance. And so it's a sort of a hybrid status that allows you to have essentially a company that's set up for profit, but you're planning to do something that sort of seems unprofitable with those profits, like roll it over into good works or whatever. There are some, because there are real limits to how much money you can give away, essentially, or do other things with if you are a traditional for-profit LLC. There are a couple companies out there that you may have heard of. Most notably, I think New Belgian Brewing in Colorado is a fairly standard company that's devoted itself to giving away its profits and doing things with the environment and stuff with what they do that fit this L3C designation. Aside from that designation, it sort of everything else that we talk about generally applies, but this is a hybrid that you can jump into. It doesn't have tax-free status. It's not a federal status, but it allows you to do certain things because other models, there basically become limits. If you can imagine, if you have a membership interest in a company that's giving away all the money at the end of the year, and you're one of the owners, you could say, hey, where's my share of the profits? And you say, oh, I'm sorry, we gave it to the Red Cross. And but if you have an organization that's out there trying to do good like that, then this is a potential model for you.
The types of things that you would want to do to get your customer base, your client list, to understand that they're not dealing with you, they're dealing with an entity in Vermont, is to get that name out there. And the ways in which you do that, you put it on the side of your truck if a truck is part of your business. You put it on your letterhead, you put it on your business cards, you put it on your estimates, you put it on your invoices, it's on your checking account. So any time that you're communicating with the public or your customer base or your advertising, you want to hold yourself out as the entity that you are so that you create a shield for yourself. And this is where the attorneys can't get the job done for you. We can set you up with the greatest paperwork and analyze your situation and put you in your best foot forward with you. But once you're away from us, you've got to hold those entities out as a shield. So if no one you trade with understands that you're an LLC or an L3C, and you've done everything with them under your name, and you've filled out invoices and traded with them in every way, shape, or form, one of the ways that you can lose your limited liability is by not using it as a shield. That individual had no idea he was or she was trading with an LLC. They thought I hired John Smith, painter. I had no idea I hired John Smith LLC. He never told me. He never showed me. So it's extremely important once you form these entities to use them as a shield with the public. And by using it, quote unquote, using it as a shield, it means every opportunity you get that information out to your client base and the public. So let's talk about tax options for the LLC. We alluded to this before. If you are starting a business from scratch and your business plan reflects a modest cash flow for the first couple of years, in order to keep things extremely simple for yourself, you can elect to be taxed as a sole proprietor. And that's the disregarded entity that Hethba referenced earlier. And as a sole proprietor, you file a Schedule C on your individual income tax return, and you pay your taxes on a quarterly basis, and with the help of a good bookkeeper or your accountant, they can determine what you should be submitting to the state and the feds on a quarterly basis, including your employment taxes, which we'll talk a little bit about. And you get the benefit of a limited liability company and its protections, but you have the simplicity of being taxed as a sole proprietor. And a sole proprietor is as simple as it comes in business. All you're doing is filing a Schedule C, and your accountant will help you with that. It's basically gross income, less expenses, less depreciable items equals net profit. And that net profit is brought from your Schedule C over to the first page of your income tax form and is listed as your income for the year. So it's a very simple method, and any good bookkeeper can help set you up for success with a single person LLC. Then we go into multi-person LLCs. Again, you can choose how you want to be taxed. And the limitations there are several of you in a multi-person LLC, so you're either going to be taxed as a partnership or you can elect to be taxed as a C Corp or an S Corp. In a partnership, it's a flow-through. If the two of you are starting a brand new business, and again, your income expectations are somewhat modest for the first few years, then a straight partnership flows through, same process, but with a partnership, an LLC taxed as a partnership, you have to file a partnership return. Each member of the partnership gets a K-1 at the end of the year as their share of the profits. The profits come out as gross profits to the partners, and each quarter, each partner submits their own individual quarterly returns, pays both the state and the feds on a quarterly basis, within 15 days after the end of the first quarter, and so forth. So that is probably the simplest multi-party methodology of filing, particularly good for startups. If you got two guys, two gals, whatever, husband and wife, modest income, partnership return is the way to go. An LLC taxed as a partnership. Now, the beauty is that a single person LLC with at least one employee can be taxed as an S corporation. And an S corporation is simply a tax classification based on the subchapter S of the Internal Revenue Code, or subchapter C, as IBM is a C Corp, subchapter C of the Internal Revenue Code. So you can elect to be taxed as a multi-person LLC, partnership, sub S, C. And I'm going to come back and go into more depth with each of those. So I'll let Hethba talk about corporations, and then we'll come back and build on those basics.
Okay. So we've spoken a lot about LLCs. Now we're going to talk a little bit about what is a corporation and how is it formed and some of the formalities that you need to start. So The LLC, as you may have picked up, is a little bit simpler in terms of formalities and processes. The corporation has certain things that you need to do. So first, a corporation is an independent legal entity. We've heard the term corporations are people in the news somewhat recently. It's separate from the people who own it, control it, and manage it. The owners in a corporation are called shareholders, and they own shares or stock in that corporation. And the shareholders are the persons that have limited liability in that corporation. So a corporation lives on if the shareholders change, if some of the shareholders die. As long as the shares exist and are issued, that corporation continues. It's typically managed by not the shareholders, but directors who are selected by the shareholders. So there's a little bit of levels there. And typically officers are appointed, so that's where you would have a president, a vice president, a treasurer, and a secretary. And those people manage the day-to-day operations of the corporation. Corporations, like LLCs, can enter into contracts. The corporation can incur debt. But one of the differences is that the corporation, in certain circumstances, will pay taxes separate from its owners. So rather than tax being passed as a disregarded entity through the member of an LLC, and Chip will probably clarify this a little bit, the corporation itself is taxed on profits, on income.
If it's a C Corp.
If it's
IBM, C Corp, anything that's C Corp. A lot of small businesses in Vermont are in fact C corporations. So there are specific reasons for that, and we'll talk a little bit about it.
Right. So, and then some of the formalities that you will need to follow. The first is you'll need to file your articles of incorporation with the Secretary of State, and then you'll need to have an organizational meeting with shareholders, an organizational meeting with directors. You'll need to have bylaws, you'll need to issue stock, and you'll need to have resolutions for actions that you'll take as a company. So you can see there are a lot of more formal steps that you really need to take to organize that corporation, and then as you continue running that business, continue to have annual meetings of your shareholders and directors, keeping minutes of important decisions and records, and so on and so forth.
You know, LLCs were designed to be basically easier versions or easier variant of a corporation, and so the corporation is both has greater requirements in terms of having meetings and stuff like that, but they're also held to a higher standard as well by the courts. So, in addition to everything that can cause an LLC to have the individual liability shield be defeated that we talked about before, corporations are typically held to a higher standard failing to adequately capitalize a corporation. So we just say you create a corporation that looks great on paper but doesn't really have any money behind it, and people could end up getting defrauded in a way. Something that failing to really issue the stock in some sort of formal way can be a real problem. Failing to regularly hold these meetings with your shareholders and your boards of directors.
For example, in the corporations, you have to have annual meeting of shareholders, annual meeting of directors, ratification resolutions to approve acts taken out of the ordinary course of business. You need more formality paperwork when you start up. So the standard for dotting the I's and T's in a corporation is a little higher than it is for an LLC. Particularly making decisions. You're going to have record of all key decisions that the corporation makes, either by unanimous consent or through a meeting and a vote. So the courts have been particularly stern about entities that have not even attempted to meet the corporate formalities. We had a case that came out of the Federal District Bankruptcy Court in Vermont about 5 to 7 years ago, and that case basically said, and there was some allegations of fraud involved in it and so forth, but the basic holding of the bankruptcy court was, look at corporation, you have no paperwork. You haven't done any of the formalities that state statute in Vermont require. And if you don't meet the formalities, we're not going to give you limited liability under the statute. So essentially, there were a couple of investors, if I recall, in that case. And what happened was they effectively pierced the corporate veil and said there is no corporation. So the two promoters of this corporation weren't doing things by the book, so to speak, meaning they probably were a little slippery in their approach with their creditors and made them all kinds of promises and told them a dog and pony show, and effectively took the assets and sold them at cost and put the money in their pocket. But there were a couple of investors, and the problem that the investors had was once the corporate veil was pierced, they're a partnership and they became the deep pocket. So you have to be very careful about meeting the formalities in a corporation. There are some formalities that ought to be met in limited liability companies, but a corp, you really need the assistance of an attorney to put it together and to keep the records up. Otherwise, you run the risk of having the corporate veil pierced if you don't meet the formalities. And to what degree we have to keep it up? Do they have to be perfect, or can they be pretty good? And that's a question that we're not sure, because the bankruptcy court just said, look, if you made no attempt to meet the formalities required by the statute, you've got nothing. Does that mean you need perfect records? Does that mean half is good enough? And the answer is we're not real sure. So if you have an attorney that does a lot of corporate work, they're probably going to doc your file real well if they practice on a regular basis in that area. So there are some advantages of corporations, and that's what we'll talk about next. If you're bringing in a number of investors into the business and you want to market this like Ben and Jerry did, if you recall, Ben and Jerry invited Vermont investors to come in, and many Vermonters actually did very well by owning Ben and Jerry's stock many years ago. And so if you're looking for money, private money, public money, corporations can be an easier tool to work with, even though they're a bit more formal and they're a bit more cumbersome. There are methodologies of creating financing that are more easily accomplished with a corporation. There is also the opportunity to, in a C corporation, to hang on to some of the income and pay tax rates. Smaller C corps particularly, it's called income splitting, and pay tax rates that are much lower on the first $75,000 worth of profit. So it's a methodology to accumulate some funds to buy new equipment and not have to pay as much tax on it. So they can be an advantage in that fact pattern. It's a big advantage to have shares of stock when you're talking about making gifts to family members. And if the gifts are done properly with good planning, over a period of years, you can move a lot of asset from one generation to the younger generation if you have some time to plan and you keep your gifts under $14,000 worth of value on an annualized basis. The $14,000 is a freebie for gift tax purposes, and any value over 14 can affect your lifetime gift-giving ability. In a modest Vermont business, there wouldn't be any tax due if you gave over $14,000 in value. It would just come off your lifetime gift-giving ability, but you do have to file a gift tax return. So we try to keep most of our planning under that $14,000 for a typical small Vermont corporation who intends to move assets to their children or other family members. And the other advantage of a corporation is you can have up to 4 officers waive workers' comp obligations in Vermont. And if that is one's goal, as opposed to covering those officers under the workers' comp statute by buying an insurance policy, a workers' comp insurance policy from your insurance agent, then the corporation is a better tool than an LLC in some instances, because you could be the president and you've got your 3 cousins that work for you and you make them all officers so you don't have to cover them under workers' comp. The downside to that is if you don't cover those officers under workers' comp, they retain any common law claims that they may have against you. So if you don't provide the proper safety equipment, then your own employees can come after you because you didn't do that if they're officers and you had them waive under workers' comp. So there is a downside to it, but you can't imagine how many small businesses will do that, even though they're read the Riot Act on the risk. So we'll talk. There are a number of kinds of classifications of corporations that are related to state law, not the Internal Revenue Code. The C Corp and the S Corp relate to the Internal Revenue Code. Here, what we've got is various state classifications for corporations. And the first is a general corporation. It's been around for 100 years in Vermont, quote unquote 100 years. And it is your standard Vermont corporation. It was extremely common for many, many years and still is a common form of corporation. But 20 years ago, we had a separate corporation act passed that allowed for what we call a close corporation. And a close corporation is a bit more simple to put together, a bit more simple to maintain. It's suited for small business where the shareholders run the company. You can set it up with a board of directors who hire officers, and they probably the same group of folks who the officers run the day-to-day affairs of the business. So you have shareholders appointing directors who appoint officers who run the business. So that is your traditional model of a corporation. You can do that in a closed corporation, but you can also create a shareholder agreement that allows the shareholders to manage the corporation by agreement. And if you're clever enough to put all the various potential issues together in a contract, then it becomes very effective. We don't use a shareholder-managed corporation very often because we find the banks are uncomfortable with them. The banks for 100 years have been trading with corporations in Vermont. They're used to shareholders electing the board appointing officers, and the officers running the business on a daily basis. Profit corporation subtypes.
Yeah, so these are very much, I won't spend much time on this, very much like the analog that exists in the LLC context. They're professional corporations. It's a separate breed required by some professions. If it applies to you, you probably already know it. There is the equivalent benefit, sometimes called B Corp, which is not a tax status like S Corp or C Corp. I wish they'd done something differently, but it's not. But it is one of these low profit or not exactly for profit entities. It's a good choice for people who are thinking of becoming a nonprofit under the federal code without having to jump right into that. And it's a better model for people who are not really going to be driven by the profit motive if you have other people to deal with in your company.
It saves you from being sued by your shareholders for not maximizing profits that you gave half your profits to charity. So that's really what it's used for, is when you have a social mission involved in that benefit corporation.
Yeah, it sounds silly, but it is important because you can find yourself in a position of not being able to do what you want to do with your company because you have one disgruntled shareholder who wants a share of the pie. So you create a B Corp and you say, hey, you remember, we were going to give all this money away anyways. It's right in our name. We're a B Corp. And then there's a workers' cooperative, which is a unique form of owning a business basically where the workers own it. If that applies to you, there's a statute that permits that to happen. Probably most people, it's not. It does not typically mean the single member, your little framing company or something like that where you do this. Is typically for a larger company like Intervale, I think, is one here in Burlington. I think they're a workers' cooperative corporation. Cabot is probably the best known, the creamery owned by the farmers. It's for that sort of thing, larger companies typically. I've rarely seen it in anything small.
So let's talk for a minute about taxation for corporations, and now I'm going to talk a little bit more about the C and the S Corp. If you recall, when we talked about LLCs, we could be taxed as a single-person LLC as a sole proprietor, a multi-party LLC as a partnership. an LLC can also be taxed as a C or an S. So I'm going to talk about it in the corporate realm, but everything I say is true both for the LLC and the corporation, either taxed as an S or taxed as a C. You make your election. That's the beauty of the Internal Revenue Code. They call it check the box. Check the box for how do you want to be taxed. And of course, before you can determine how you want to be taxed, you have to sit down with your CPA or an attorney who's fairly familiar with the taxation of these entities and say, here's what I think is going to happen in year one, here's what I think is going to happen in year two. And based on those indications, the attorney or the CPA can put a plan together for you. So a C corporation, and we do have a lot of small business Cs, it's much more common to see an S, but a C is simply a corporation that does not make an S election. So if you fail to make an active S election, you are a C Corp if you form a corporation. And the significance of the C Corp is the double taxation. You create your profits, as a corporation you pay tax on those profits, and when you distribute dividends, then those dividends are not tax deductible to the corporation. They've already paid the tax on the profit. The actual dividend to the shareholder is not tax deductible, and the individual recipient of the dividend is going to pay tax on that. So you have a corporate tax, and the individual shareholders of that, it can be IBM, where you receive a dividend of 3% from IBM in a successful year. They've paid tax on their profit. They don't get a deduction for sharing those profits with you. You pay the tax on the dividend when you get it. So it's not an ideal methodology for all businesses. A small C corporation in Vermont, there are some advantages to it. You get to deduct your health insurance if you own a C Corp as opposed to an S. You do not get to deduct. You get a 1099 for your annual health insurance, and if you have a family plan, some of you know it can run you $15,000, $15,000 for a family plan, and you don't get to deduct that. That's income to you. You get a 1099. Your accountant will prepare that at the end of the year. So the C Corp has that advantage of making the health insurance deductible. A C Corp is typically an entity where you're going to make about the same amount of dollars every year, and you're going to pay tax on it, and you're not too worried about having a big year and having a surprise income tax that flows through to you. So it works for a business that's fairly small, fairly steady, and has a big family and wants to take that deduction as an owner for health insurance purposes. The S corporations, on the other hand, are a flow-through to the individual shareholders. So if you start an S Corp, the IRS anticipates that you're going to have at least one employee, and you can take a wage out of your S corporation. You can take bonuses out of your S corporation. But if there's still money in the till at the end of the year, that will come to you in the form of a sub-S dividend. So let's say you're going to make $40,000, you bonus yourself out for $5,000, and there's still $10,000 or $15,000 in the till. Whether it's an inventory or whether it's still sitting in the till or whether you've taken a draw on it, doesn't matter. If there's $15,000 more, then the S corporation owner can take that out in the form of a subchapter S dividend. Now, the advantage of a subchapter S dividend over straight wages and bonuses is that you don't have to pay the employment taxes on subchapter S earnings. Employment taxes are shared between the employer and the employee. Both pay 7.65% of the 15.3% that's due. So let me give you a fact pattern that will show you where you can save some good money in the right fact pattern by being a subchapter S corporation. Additionally, the LLCs can elect to be taxed as a subchapter S corporation. So as long as you have one employee, you would be eligible to make that election. Let's say we have $100,000 coming at you. You're the sole member of the LLC or the sole shareholder of the corporation. You put yourself on a wage of $55,000. Your accountant says at the end of the year you better take a $10,000 bonus. It's all ordinary income. You're going to pay 15.3% employment taxes out of the corporation and your contribution, it'll be 15.3% total on that $65,000. But because you had an extraordinary year, you have another $35,000 either in the till or in inventory or somewhere that you haven't taken out of the account as of 12/31. That $35,000 is considered a sub-S earning if it's not paid out in the form of wages. The beauty about that $35,000 subchapter S dividend is that you don't have to pay the 15.3% in employment taxes on that $35,000. You may have to pay the Medicaid taxes at 2.9%, but you don't have to pay the full 15.3%. So when you start talking about 35,000 times 15.3% or 40 or 45,000, it can turn into $3,000, $4,000, $5,000 pretty quickly. So the sub-S corporation for a business that's going to net pretty much 60,000 or above, there's a real opportunity to save some employment taxes out of an S corporation or an LLC that's elected to be taxed as an S corporation. So that's something that we try to plan for our clients. One of the beauties is you can come in as a single person LLC, you can file the simple quarterlies and do a Schedule C, but by year 3, if you're starting to cook with gas and your net is 55, 60 or better, we might be able to put you in a position where you can save some money by electing the S. And we have many of our clients that start off as sole proprietor LLCs, and after 2 or 3 years, if they've had success, they've got an employee or two at that point, they come back and we make the 2553 sub-S election with the IRS. So that is something that, if you really succeed, you want to remember to talk to your accountant about moving from a single person LLC. We're starting to make some money. How's an S look now, Mr. Accountant?
So this is sort of an important piece. When you want to be an entity, you're going to operate as something. You need to do an initial filing with the Vermont Secretary of State. So for your LLCs, that's going to be an article of organization. For a corporation, that's articles of incorporation. So it's, as we mentioned, important to look up your name before you start using it. So verify that your name's available, and then go register it with the Secretary of State. We're very happy to help you with that. I have a lot of experience filing a lot of articles of incorporation, organization. Other things that you need to do every year to let the state know that you're still in business and you're still active, you need to file an annual report. You have to do that for an LLC, for a corp, for an LLP. And the purpose of that is to verify your information. If you have officers that have changed in your corporation or you've changed the managers or members, the state needs to know that. Banks will look at the Secretary of State's website to verify, are you a member? Are you a manager? Are you authorized to sign on behalf of that company? That's where they're going to look. So it's very important that your information is up to date on the Vermont Secretary of State's database, and that you're listed as active and in good standing. And the way you do that is by filing your annual reports. The periodic filings are just what the name implies, which is, so say midway through the year someone quits the business or they've been kicked out or whatever the case might be, and that person is no longer a manager of your LLC. You want to make sure that you update the Secretary of State so that when you go to the bank and you go to get a loan, they say, well, you're not the manager. John Smith's the manager. It's important to file those articles of amendment to amend your record with the Secretary of State and let them know what the change might be. You might also want to change your name. Maybe you want to take John Smith out of the name and it's just Jane Smith's Ironworks. You file articles of amendment to do that. So
we have little time to get some questions, and I know there's a lot of good content, so start.
What's the importance of having an EIN number if you're an LLC sole proprietor?
Yeah.
And also if you use an attorney, and I don't mean to set you up for this, but how expensive is it to do this?
It's not. We kind of use our LLCs as a loss leader just to create relationships. We flat fee LLCs depending on how much we have to do between $695 and $795, we get the information first, and then we give them a quote as to where they're at. So it's not inordinately expensive. The reason that you would want an EIN as a sole proprietor LLC, a single person LLC, is so that you don't have to give your Social Security out to any of your vendors. If you're going to potentially get 1099s from some of the vendors, if you're in personal service, you don't want to be giving your Social Security to anyone but your bank. And if you're never going to open an open credit account with Home Depot or Lowe's, and you're not going to get any 1099s from any of your customer base, then you can just use your Social Security number, because the only one that needs it is the IRS, the state of Vermont Department of Taxes, and your bank to run your business checking account out of. So it depends on your needs. If you are a subcontractor and you're doing work for a lot of generals, you're going to have to get an EIN, because they want an EIN to issue you a 1099 at the end of the year. Otherwise, they'll pay tax on money they paid you. Question?
So in that case, do you file under your EIN or your Social Security number, your tax return?
Well, if keep in mind, if you're a sole proprietor, single person LLC, you're doing a Schedule C on your individual income tax return. It's already got your Social Security number on that income tax return on the front page. So you would have no problem with the IRS if you decided to use your social. It's really a business decision based on whether you're going to have to give your social out to anyone other than the bank. If you're going to give that social out to anyone other than the bank, then we will look at you and say, let's get you an EIN. And it's all part of that flat fee. I mean, we give the education, we provide all the documents, we register you with the Vermont Department of Taxes, we get you the EIN. It's kind of a soup to nuts flat fee, so people know exactly what it's going to cost them when they come see us for a new LLC startup. Did I answer your question? Good.
Another question?
Sure.
So, me and Aaron are going to go into business together. We're looking at the difference between the partnership and the S-Corp.
Mm-hmm.
We thought we were leaning towards the S-Corp, but listening to you talk about the differences, seems like it'd be better to go the partnership route first and then convert into an S-Corp later.
Well, what we would do, or what your accountant would do with you, is quiz you up on what your anticipated income for 2016 is going to be, your net. Now, you've obviously got some startup costs. You may need to buy some equipment. You may need to buy some tools. You may have a bigger expense than you will in year 3 or 4. If you're bringing all of that stuff with you as a startup, you've got all the tools, you've got all the basic equipment you need to do business, then you can depreciate all that stuff that you bring in. If it hasn't been depreciated before, you can depreciate it based on the fair market value. And that's very helpful in year 1 if you buy equipment, because the depreciation offsets some of the income. So you would have to put together a business plan or guesstimate the best you can as to what your bottom line success would be from a dollar predicament. If you think you're going to make $30,000 or $40,000 each in year 1 because you're just getting rolling, in that case we'd set you up as an LLC taxed as a partnership. And in future years we'd keep an eye on that to determine if there's going to be some benefit for employment tax savings when you get to bigger numbers. So if you're truly a startup and you don't think you'll make more than $50,000 a piece in year 1, we keep you as a partnership because it's simpler for you. You have to file a partnership return. You pay a minimum tax of $250 to the state, but you can take gross distributions out of the partnership, and you're both responsible to pay your own income tax on a quarterly basis out of those distributions. So as soon as assuming you get equal checks, you're both on your own to pay your taxes. So if one of you didn't pay and the other one did, the one who did pay their taxes doesn't have a problem. The one who didn't has got a problem, and that's the worst problem you can have as a startup. If you want to see your business sink in the first 3 years, don't pay your taxes to the IRS in the state of Vermont. It's almost a death knell. And there's very few businesses that can recover from that. you really have to have a strong cash flow to recover from serious tax delinquencies. Because you have to pay the tax on the money you earn prospectively, so it doesn't leave you much if you owe from 3 years back. So it's a tough situation.
But I think, but one of the things, sorry to interrupt, but isn't it true, Chip, these days, I mean, the conversion process is pain-free at this point in terms of the election.
Yeah.
Year to year.
Yeah,
So you could
it's a
pick,
year-to-year election.
you could pick to be an S corp this year, and if things are going great or not
That,
going great.
no,
you could
that
do-
probably isn't, it wouldn't be good. You
Yeah,
could be a
it's
partnership
partnership,
this year
that's what I'm
and
saying.
elect into an S next
Then
year.
you can select next
Coming
year.
out of an S means all your assets
Yeah,
come out
that
at fair
was
market
right.
value, and that's not a good thing.
But it's not a long-term commitment to select as a partnership return, especially in that first year.
Yeah, and it's all based on net dollars. So, and you both would become employees, so you've got two of you, so you'd be eligible to take sub-S earnings right off the bat, unlike a sole proprietor. We have sole proprietor LLCs that hire their spouse to do books and to do various secretarial chores or consulting advisory stuff just to get a second employee on there.
Well,
Question?
Okay, so say you own a couple properties that are under various LLCs, like you said, the addresses,
Yeah.
and folks are writing you checks, would it be acceptable to have them write them out to you, your name personally, and then in the memo say the 340 LLC or the...
Not a good idea. Can't condone that one. What you can do is form a management company, and we have a lot of our clients that are bigger landlords that either form holding companies when it's husband and wife, so that they only file one tax return for the husband and wife partnership with 5 LLCs, all disregarded entities up into the partnership. But we have a lot of clients who have 2 or 3 or 4 buildings, and they form a management LLC, and the lease will say that the owner of the property is thus and such, and the check should be made out either to that LLC or the management company, who can be who can take care of the books as well. You know, take the checks, take the books.
It's always dangerous to have your name on the check, because the first question the judge will ask is, why is his name on the check, if it's really the LLC?
So yeah, that's a good question, because I get that all the time.